Hello, everybody. Oh, yeah, you start out with that while I still have a shiner from yesterday. Oh my goodness, the star of the show. She's waiting here for her appearance too, y'all. She is right here, like, I know it's my time to shine. Come on, baby girl. Come on. Your audience awaits you. Yes. Come on up. Yes, just don't punch me in the face today. Hi. Hi. Oh, I know. I forgive you. How y'all doing? So good to see you. My camera's doing all kinds of goofy things. Owie! Oh, thank you so much. And I saw Kiki Blue got it. Hello, Auntie M. Oh. Hello, Joey Bag of Donuts. Hello, Nana Laura. Hello, Sir Philip from Mali, Victoria, Australia. Hello, Kiki Blue and Rocky Lennon too. I saw Kiki Blue in here and now I can't find her. But I know she was. Oh, there's my Nicola Maxwell. Oh, maybe it was just the notification that Kiki Blue's the one that got the free membership. That must be what I saw. The gifted membership went to her. And I just assumed that meant she was here. And then, hi, Rocky Lennon. Okay. Treats are coming. My gosh. Can't get away with nothing around here. I cannot even have a stream. PAWFURM present. Whoa. Hey there. Hey there, Captain Fancy Pants. My goodness. She is all kinds of excited. Oh. I know, but then if I did that, then I wouldn't be able to be here with all of you wonderful people tonight. And then I'd be sad. I'd be happy because I'd be with my crazy old Rexy. And I love her so very much. But, true. I don't have bail money. Yeah. That is exactly it. 100%. Yep. I told him somebody could rob me blind, and as long as they had treats, she'd be okay with it. They're gone. And so is she. She's like, no more treats? Okay, I don't care now. Come back up here and love people. Yeah. Yeah. You're so spoiled and you know it. You live in the life now. And he shall forever be known as Yes, Earl. Oh, I tell you, some days. You guys can't be mad at me tonight. It's not allowed. It's not allowed. The second case of the night, there is no ending. It's a what do you think happened kind of case. The judge cut the feed before he gave his ruling. But it's still worth a listen. It really is. Meow. Meow. What are you trying to tell me, Earl? Well, I know that. But why? What? Oh, now you gotta go potty? I'm sorry, guys. I'm gonna have to start the clip like right now. I promise after clip we will hang out and stuff, but I'll be right back. As you can hear, something's going on. I'm coming.
5th District Court is now in session. The Honorable Judge Iserloh presiding.
All right, good afternoon, everyone. It's Judge Iserloh here of the 455th Civil District Court. We are here in cause number, I believe on the record, we're on cause number GN 24-001696. This is a 2.6 assignment case, although this court is currently on the family docket, since it's been specially assigned. We are here with you on a civil case. We are here on a motion. I must admit, I've never seen a motion entitled this before. It is, or heard of one in my, over 30 years of litigation prior to taking the bench. We're here on a cross motion to enforce the local rules. So who set this motion?
Your Honor, I set this motion, Matthew Zorn, for defendants Heldreth, Symposia, Psychedelics Today.
All right, very good. Who else is here on behalf of defendants? Okay, who's here on behalf of plaintiff?
Me, Your Honor. George Greg Lake.
Okay, all right, Mr. Lake.
Your Honor, I'm sorry, Your Honor. Greg Noche and Liza Eoff for the USANA Promega defendants.
All right, so I'm trying to figure out, are you and Mr. Zorn, are there different defendants here, Mr. Zorn, that you're representing? And then we've got the USANA Promega defendants.
There are two different groups of defendants, Your Honor, and I'm happy to explain the difference and maybe giving the court a little bit of an orientation about the case before I explain the motion and the necessity for the motion in this case.
Yeah, that might be helpful. I must say, joint motion to enforce the local rule is a little unusual, as you all can imagine. So let me hear from you, Mr. Zorn.
Yes, Your Honor. It's an unfortunate motion, and I think it would be helpful if I just orient the court a bit about what this case is about, and then I will get into the substance of the motion.
Right.
And so in many respects, this is probably going to be a standard fair Texas citizens participation or TCPA case.
Mm-hmm.
From our viewpoint, this is a case about plaintiffs' attempt to retaliate against all of the defendants for exercising free speech rights, and in particular, alerting to the public to a possible public health risk and frankly, fraud, Your Honor. And there are some unusual facts to this case. There are two groups of defendants in this case. So there are the USANA Promega defendants, and then there are the republisher defendants. And I'll explain the difference in just a moment, but I'm here representing the republisher defendants, comprised of journalists, scientists, and social media personalities. Here's the gist of the case. The plaintiff, the Church of Sacred Synthesis, says it has a sacrament that has a molecule in it called silomethoxin that it distributes to its members and that its members use religiously. The church not only makes this substance and distributes its sacrament to its members, but it also offers the sacrament for sale on a website. in a marketplace, for example, at
Sorry, guys.
.com/marketplace, you can buy a sacrament bundle for $145. You can buy 30 sacrament capsules for $100. Or you can buy a chocolate bar that has some sacrament in it for $65. A couple weeks ago, the church had a Memorial Day sale where you could get sacrament for 15 or 20% off. Now, what this case is about is the USONA and Promega defendants obtained one sample of the so-called sacrament. They tested it, and they did not find any silomethoxin in it. Instead, they found psilocybin, which is the active constituent in magic mushrooms, which are controlled substances, Schedule 1, under both federal and Texas law, which means they're illegal to possess, use, consume, and so forth. Then the USONA Promega defendants published an article on the testing that they did, explaining the results to the public. And I would just alert Your Honor, nobody that's tested the sacrament has, with any level of scientific rigor, has found any silomethoxin in the sacrament at any point in time. And I need not belabor this point. Basically, in certain respects, by all credible proof, the church is selling magic mushrooms online. Now, in the case of the Promega USONA defendants, it studied the sample and published that result in a scientific journal online. Some of the other Promega USONA defendants, including Promega itself and its CEO, appear to have absolutely nothing to do with this case and were simply brought in by plaintiffs for reasons I cannot explain. In the case of my clients, the republishing defendants, they essentially wrote articles or commented on the USONA Promega. It's not even USONA Promega, it was just an article written by two of the defendants in that group. And so their acts range from basic journalism to opinion and criticism, calling into question the church's practice. And so very shortly, Your Honor, the defendants will be filing a Texas Citizens Participation Act motion asking this court to dismiss the case because, among other glaring deficiencies in plaintiff's case, there's no credible evidence, let alone clear and specific evidence, to substantiate the existence of silomethoxin in their sacrament. In fact, if you were to go to the Wikipedia page today, it would call that molecule hypothetical. Now, that intro is just to orient this court to some of the unusual facts of this case. And now I want to talk about the unusual motion that I brought to this court, because over the past several months, it's become clear to us that plaintiffs and their counsel have expressed an unwillingness to abide by unambiguous rules. And then when we bring that to their attention, they concoct reasons ranging from unreasonable readings of the rules to no harm, no foul for why the rules don't apply to them. So the present motion has to do with pre-motion conferences. Plaintiffs didn't confer with defendants before filing the motion. And to be sure, I discussed with plaintiffs' counsel the subject of the motion, which was a motion for substituted service, because I told plaintiffs' counsel that we would agree to waive service days before they filed the motion. And so there was resolution of the issue. And I said, just give me a couple days, I will get the papers in. Your Honor, I had 2 depositions in very large matters and had the affidavit right in front of me and I was ready to file it. And plaintiffs went ahead and filed their motion anyway, saying nothing of the fact that we agreed to waive service. And then in subsequent correspondence simply misrepresented what had happened between the parties. And then in their response, the court can see that their interpretation of Rule 2.2 is that pre-motion conferences only need to happen after a hearing is set on a motion, which is completely contrary to the text of the rule, which says that all non-dispositive motions require a certification that the parties have conferred. And the reason why is fairly straightforward, which is to avoid having to bring needless motions to the court. And I should note, Your Honor, that plaintiff's motion was sort of the archetype of a needless motion because, again, we agreed to waive service, so there was no need for substituted service. Now, that isn't the only reason why we have brought that to the court, because this is not proving to be an isolated incident. In fact, there are more serious violations of rules that we have put in our reply brief that I think it's important for the court to know. One of them is plaintiffs insist in their response that my clients weren't officially represented. That's a phrase in the response by me, even though I expressly told their counsel orally and in writing that I represented them, two of the defendants. Knowing that my clients were represented by me, plaintiff's counsel contacted my clients directly without copying me on the correspondence. Plaintiff's counsel knew they were represented by me because I told him, and they went behind my back and talked to my clients in an email.
It's a huge no-no.
More concerning, in an effect, it is as part of what appears to be a fact-gathering operation to complete service, plaintiff's counsel impersonated a fake individual and contacted the USONA, one of the USONA defendants, USONA. And this is beyond dispute, Your Honor, because there's a recorded voicemail of plaintiff's counsel purporting to be a person named G, contacting them to, I don't even, to donate money to them. But this was one day after plaintiffs sent a demand letter to USONA. Plaintiff's counsel calls impersonating an individual named G, and then also sends a written communication where plaintiff's counsel purports to be a Roger Growing, and then sends contact information with an email that plaintiff's counsel's email, and that's in our reply brief. It's in a footnote. And then when we confronted plaintiff's counsel with, frankly, these unimpeachable facts, plaintiff's counsel floated conspiracy theories like his phone being hacked, and then simply stated he never misidentified himself, even though it's pretty clear that he did. And finally, there's now a motion on the docket for a protective order. Plaintiffs seek discovery of a third party to get information on my anonymous client who offered criticism anonymously and wants nothing to do with this case or plaintiff's enterprise. I have no idea why. He's a social media, a small scale social media personality, and he doesn't want to be publicly associated with this case. And most importantly, I told plaintiffs we'd be willing to waive service if we could maintain his anonymity through the opening of discovery, and plaintiffs refused. So I have strong suspicion that plaintiffs have included him for improper purposes in this case. Suffice to say, plaintiffs aren't entitled to discovery before third-party discovery before the discovery period opens, and yet it's another instance of plaintiffs believing that the rules don't apply to them. So in sum, that's what this motion is about, and it's an unfortunate motion, but it's one that is the plaintiff's unwillingness to abide by clear rules is starting to cause serious harm to people in this case already before it even gets off the ground. And so, at this juncture, what we're asking is, going into this next phase of the case, at this juncture, we're asking for a court order that the procedural rules, that the parties need to abide by the procedural rules, because whatever their religious beliefs may be, belief is not a basis to not follow the rules. Like, the plaintiffs need to follow the rules, and so do we, and that is the purpose of today's motion.
All right, thank you very much, Mr. Zorn. Mr. Noskazi, did I say that correctly?
Actually, Your Honor, you did in terms of the Italian pronunciation, but our pronunciation in our family has changed over the years, and it's Noche.
Noche. All right.
Yes, thank
Well,
you.
I'm glad at least I got the Italian pronunciation correct.
That is correct.
Mr. Noche, what do you have to add to what Mr. Zorn has provided, if anything?
Miss Eoff is going to address that, Your Honor.
All right, Ms. Eoff, what else do you have to add to what Mr. Zorn has just presented?
Mr. Zorn has adequately explained what has happened with respect to our clients. We do have a motion on file to stay discovery because the discovery period has not opened. I can confirm that we explained the rules several times to Mr. Lake, and I believe he just had an outdated copy of the rules, and that's why there was some confusion. And so we're here to verify that what Mr. Zorn is correct as far as what's been going on, but this is his motion.
Thank you very much. All right, Mr. Lake, please unmute yourself and let me hear your views, okay?
Yeah, thank you, Judge. And I guess if you don't mind if I start out giving a little bit of our side of the background, leading up to this case and kind of what this case is about.
Oh, please do.
And
Right.
briefly address these local rule alleged violations. I'm an attorney in Texas, and another attorney in Texas is a good friend of mine, and we are what we would call entheogen-based religious practitioners. We claim protection under the Federal Religious Freedom and Restoration Act of 1993 and the First Amendment, and also the Texas Freedom and Restoration Act, I believe, of 1999. Which provides commensurate, and if you ask the Fifth Circuit, in some cases, possibly more protection than the federal counterpart. But anyways, we ran across, and my partner had been on a very long spiritual journey to find a molecule like silomethoxin. And he came across some literature from a very respected, but not with us anymore, chemist named God, his name Shulgin, Alexander Shulgin. Anyways, Alexander Shulgin proposed if you put, on a cow patty with hallucinogenic psilocybin mushroom substrate growing in it, 5-MeO DMT, 5-methyloxyl dimethyltryptamine, which are both, these are all three together are controlled substances. Silomethoxin is not a controlled substance. Now there are residual amounts of psilocybin and psilocin left over in our sacrament. Now, when we first began our church way back in 2020, we did not immediately open it up to the public. We actually went and served a little bit over 1,200 people who all gave the same feedback. No negative health reactions. That was our main concern. And then two, that there was a absolutely unique effects profile from these mushrooms from any other mushrooms that these very experienced people have created. So in September 2022, we decided we went public with the church. Despite, now, yes, it is a lot easier to get sacrament from our church, but that is more or less a function of what has been caused by these defendants. Within September through April of 2023, we saw significant growth. And I don't know if that upset the USONA defendants or how we came on their radar or of any degree, but we had been making strides because part of my clients, the church's liturgy, is this idea that science and religion and spirit are not neatly compartmentalized things, and that, especially through the study of psychedelics, we're starting to realize that, these two things overlap in many ways that we don't quite understand. And so it's part of our religious practice to further understand the interrelationship between those two types of dichotomies. And so, yeah, so anyways, our plan was, once we get up and running, we get membership in. We had about 2,000 members whenever this happened. We were doing really well. We were bringing in almost $100,000 a month in membership fees and sacrament sales. And, but at that time we had not had enough money to save up to get our own testing facility, because as you can see from what's happened in this case, you can't just go to any willy-nilly person and ask for a test, to test your stuff and trust that what they're going to come out with is truthful. And what we found out probably about 2 months before suit was filed here was that if you test our sacrament with water, unlike methanol that USONA Promega did, again, and Matt was right, this is kind of there is no reference sample currently existing for this molecule, but USONA did make a guess at what the weight would be. And when we tested our sacrament with water, consistently every time we're pulling up a molecule with that exact same weight. And so we are in the process of creating the NMR reference sample to absolutely confirm 100% that there is solid methoxy in our sacrament. And I will say this before I turn to the, just real quick and address the local rules, is that I have a billionaire client that is in Nebraska that was invited to USONA Promega facility and was told some things that seemed to indicate that they knew before they published this article that that they knew that this was not the 100% truth. But we will prove that in court. Don't take my word for that. That's just something I'm throwing out there. But with that being said, look, on the local rules, I did maritime litigation in Louisiana for close to 4 to 5 years before I completely switched over to doing this. I had never had to single-handedly deal with so many defendants at one time to try to get them served in such a short timeline, like a defamation claim with a 1-year statute of limitations. I did the best I could. I thought that I was really just following through with my due diligence.
Yeah, he's an actual legit lawyer, passed the bar and everything.
With Mr. Zorn, I've known Mr. Zorn. We've had a prior relationship, and I consider us to be friends. And he just, it kept saying one day, give me a couple more days. We're going to get this. And there's a lot of republishers here. So, his claim to represent all the republishers. But if you ask him one day if he represents Gordo Tech, and if I can get, instead of having to subpoena, a Patreon to get his anonymous information, I will be filing a motion very soon because I just amended my Second Amendment petition to basically include constitutionally sufficient evidence to create a prima facie case against Gordo Tech that would basically give you the green light to give a order to compel Patreon to disclose to me, regardless of when the discovery period starts, because this is a third party. I'm not even really sure how applicable this new third party rule, and I was mistaken at first, and I do apologize to everyone on the USONA side for being mistaken about the rule. I had an old version of O'Connor's, and I wasn't aware of the new amendments that had taken place. But now I am very well aware and ready to proceed that way. Lastly, I do. Unfortunately, this has caused me a lot of stress. My normal work plus taking on this litigation. And I had a couple seizures over the course of about 3 weeks. And I honestly do not remember placing these 2 phone calls to USONA. My wife tells me that I did make the one with and identified myself as G. Why I did that, where I was mentally when I did that, I do not know. I apologize. It will never happen again. As far as the other one is identifying myself as a Roderick or Roger or something, I don't have any record of it. My wife does not seem to recall me making that phone call. But she did hear me call them and what we were doing, we're seeking better service information to get them served. Is what was the cause of the matter.
Terrible
All
plan.
right, very good. Thank you, Mr. Lake.
Yes, ma'am.
All right, so I've heard now from Mr. Zorn with the republisher defendant. I've talked with Ms. Eoff, who says that she is going to rely on the arguments made by Mr. Zorn at this time. I realize there's some other motions, but they aren't set today. And I've had the opportunity to hear from Mr. Lake, who, are you currently licensed in Texas or are you pro se?
I'm currently licensed in Texas, and I will say it due to my physical ailments, we have been able to, I think by the end of this week, we'll have a firm out of San Antonio basically taking lead counsel for us in this, because there might be a chance I might have to be a witness. So, you know,
Right.
in case that chance comes, we'll have someone there who can take and, you know, there won't be any issue and we can keep this thing going smoothly.
Mr. Lake, I would strongly recommend that. I think it's very difficult to represent an entity that you have strong beliefs about.
It is.
It's hard to keep your emotions out of it, and that can really sometimes not benefit a party in the courtroom. So I would encourage you to get that law firm that you mentioned, or any reputable firm, to help you with the case. So
Yes.
today we have to take what we've got. All right, so Mr. Zorn, let's go back to you. So it looks to me like what you're asking me to do is to sign an order that says follow the local rules, but you're basically already an order. Is that what you're wanting? I mean, or is it more the type of thing where you need me to hold them in contempt? I guess that's the question. What do you want from me today?
Your Honor, we do not want an order, a contempt order today.
All right.
The operative word being today, that is not what we want. We do not want sanctions. We do not want any affirmative punishment today. But we do believe a court order saying that the parties need to abide by the local rules would then be a court order. And then going forward, the parties would need to adhere to the rules and maybe if it continues, again, a very unusual motion, but as I've narrated to the court, there have been some serious events that frankly just need to stop. My clients cannot be contacted by Mr. Lake without going through me when he knows them to be represented. That is my main concern at this juncture. And so, and similarly with the procedural rules, it can't, going forward, it can't be the rules don't apply to us. So that's all we're requesting today is a court order saying that the local rules apply to everyone, and going forward, there could be contempt penalties.
Yeah. Well, of course they do apply to everyone. They already apply to everyone. I can't really issue an advisory opinion, you know?
Well, then, Your Honor, we would ask that simply the court note that the local rule was violated in this case, but we are not asking for a penalty or a sanction of any kind.
Right.
The motion was resolved successfully, but we would like a finding that the local rule was violated because plaintiffs did not confer on the motion.
All right, so I can't issue an order that says in the future, follow the local rules. That's already the rule. Now, what he's saying, Mr. Lake, and when I ask him about contempt, and I think Mr. Zorn is trying to keep he's trying to pour water on this fire rather than gasoline, which I do appreciate very much. I wish that more people would come into court with that attitude. That typically those local rules they already have the force of a court order. And if you violate them, you violate them. And so if you continue to violate them, they can come in on a motion for contempt, which can include fines and jail time. And I know those are things you don't want because it would take you away from the Church of Sacred Synthesis, and that's what you do not want. So, but Mr. Zorn has pulled that punch, as they say. He's not going to do that. I cannot I can't sign an order that says in the future, follow the local rules, because that doesn't add anything. It's advisory in nature. Mr. Zorn, if you want to draft an order that says there has been a violation of the local rule, and I find it, the parties are not currently seeking contempt or monetary sanction, I would sign an order like that, but be specific on how it was violated. Okay.
Thank you, Your Honor.
All right, so I'm going to go on and grant relief to Mr. Zorn today. Mr. Lake, though, please keep in mind, this is, as we used to say, it's a shot over the bow, meaning it's kind of a warning. It's a warning volley that's saying to you, You got it. I understand what you're saying. You've had certainly some very serious health issues, it sounds like to me, and I hope those are resolved with
Seizures.
seizures. I'm concerned about your well-being with that, sir. I know you have had experience practicing maritime law in Louisiana, as you've explained to me.
Mhm.
And I know that you're in the process of looking for a law firm to handle the case. I really suggest you do that, because the thing is this: Mr. Zorn, if he hadn't come in and just fired the shot over the bow, could have gotten you, he could have made you all pay some attorney's fees. I know you want that money for the church. And he could have come in here and held you in some personal contempt. And that would take, not only are you a person with some health issues, but you're also, as you've pointed out to me, extremely busy with your church and this litigation. The last thing you need is for us to impose some sort of jail time for violating local rules. Now, I'm not saying we would do that, but it's in the basket of the toolbox that we have for these types of things. So let's take Mr. Zorn at his word. He's going to draft an order saying that there was a violation of the local rules. He's going to explain it in the order. He's going to say that there's no contempt being sought and no attorney's fees. I'm going to sign that. But Mr. Lake, please, in the future, just review those local rules. They're online. They're very easy to find. So just find those Travis County local rules and read them and abide by them. Do not contact people. I know you said you don't remember it, and I'm going to take you at your word on that. But if your wife hears you picking up that telephone when you're in an altered state of mind because of health issues or what have you, please say the court has ordered me not to do that. You all figure out a way for her to nicely ask you to not make that phone call and to wait till your head is cleared. And then I want you to contact these attorneys directly, not the clients. Okay?
It was my fault, Your Honor. The statute of limitations was running up real quick. And
Okay.
I was just impressing upon her how, we need to get this filed and served ASAP, like just ASAP. And, even she was kind of getting a little bit frustrated with Mr. Zorn a little bit whenever he was kind of going back and forth a little bit. And she was like, just follow the motion, and I think we all learned a little bit now that, if Mr. Zorn tells me that he's representing somebody, even though they haven't been quite served yet and it's past the statute of limitations, I guess I just got to kind of rely on what he says.
Well, the filed and served, I mean, I don't want to tell you how to do your lawsuit, but I think, if you got it filed in a timely fashion and served within a reasonable time, you're probably okay. But I have not looked at the statute that applies to you. So
Right.
you need to get, too wound up on that. Now, here's what I'm going to ask you, Mr. Lake. I hear what you're saying. Please, when we get off this call, go online and find the Travis County local rules and read them. In fact, Ms. Guardiola, is it possible for us to put, or Mr. Agidi, possible for us to put a link to those rules in the chat box so that we don't have this come up again?
I've got them right. I was reading them prior to our hearing today, Judge.
Good.
I'm going to become an expert on them by the end of the litigation.
That's what I like to hear. All right, so let's do that. And again, tell your wife, if you start to see me when I've had one of these, bad health spells with seizures or whatnot, please don't let me make those silly phone calls to people who are represented. You need to, those calls, all of them now, you need to go directly to Mr. Zorn or to the other attorneys on this call if it pertains to them. Represented people cannot be contacted directly. That's why we have to have it with the attorneys. Okay. All right. And when you have someone call up and say, hey, can we make an agreement? If you're amenable to that agreement, which the rules require you to do that first, then that's done. That's a done deal. All right. We don't go back on that. So, all right, folks, I don't know if there's anything else I can do for you. Mr. Zorn, please draft that order. Do not make it advisory in nature. And I will sign it and send it to Mr. Lake. And Mr. Lake, you put that right where your wife can see it. And you say, look, that judge said this is a shot over the bow. In the future, we've got to be a lot more careful, or we could end up having to pay attorney's fees. We could end up being fined. Bad enough violation, we could even end up in jail. And that takes you away from your duties with the church, and that's what you don't want. Okay?
The attorneys we spoke with, real quick, Judge, the attorneys we spoke with real quick yesterday, they were just blessed that we have one judge through this whole thing. They said, look, because I like to research and write. I'm a First Amendment expert, and I like to research and write on First Amendment stuff. So, like, all I'm going to be doing from now on is just sitting back, research, writing, doing some depots and some discovery, and only talking to the parties with their attorney present.
A First Amendment expert and a maritime law lawyer. And don't forget, by the end of the day, he's going to be an expert on the local laws and procedures that they put in the chat. He's a multi-talented jack of all trades individual, my friends.
All right, that sounds good. And to the degree that you can take on more of an assistive research role than being the face of the litigation, in other words, at depositions and things like that, I would really encourage you not to do that. I think when we have to show up as attorneys asking questions in court or in deposition, because as we always say in deposition, it's just as if the judge and jury are right there when that's occurring. To the degree that you can step away and hand off those duties to the San Antonio law firm you mentioned, I think that you're going to find that your time here is a lot easier, and that we won't have Mr. Zorn, Mr. Nosage, and Ms. Eoff bringing you into court on this stuff. So, but I understand it. As you've made very clear, you have a high degree of expertise in these areas, and I have no doubt that you will be research and writing. I just kind of let that law firm take the lead in court in any kind of witness or deposition. Okay. The other thing, Mr. Lake, I want you to be aware, it looks like there is going to be a motion filed potentially by Mr. Zorn, kind of questioning the underpinning of this lawsuit. That's something he's entitled to do. The other thing I want you to be aware of is you might get some disclosure requirements. Please look at the, Texas Rules of Civil Procedure on Disclosures.
Okay.
If you get discovery coming in, please look at those discovery rules. Now, sometimes in discovery, they ask us to turn over things that we do not want to turn over. The law still requires you to get those at least to your attorney. Make sure that no matter what happens, that you put a number at the bottom of every single page sequentially from the first page all the way through to page 1000. We used to call them Bates numbers, but we don't call them. They're just numbers, sequential numbers. And that when you respond to that discovery, that you write in response, for instance, page numbers 0005 through 00025.
Okay.
If you do that, it'll make things a whole lot easier. If you just, I have a big pile of cases on my desk, but if this were a batch of discovery and I just took all this in an envelope and sent it to them, that's too hard to deal with, and that's not what the rules require. So on the bottom of each page, put it in your Adobe program. It'll put a number on it. And then when you respond to those questions, make sure to put that number in there. Now, when we hang up this call, thank you for looking at the Travis County local rules. Go look at the rules on disclosures, request for production, and interrogatories and depositions. Familiarize yourself with those. If for some reason the San Antonio firm does come in, you'll have more productive discussions with them. If they don't come in, then we hopefully won't end up here again on a motion that honestly we didn't really need to come in. Okay? All right, Mr. Lake.
99% they'll be coming in. So we'll
Okay.
hopefully by the end of this week, next week, have them as counsel, and we can just.
Okay, have them make an appearance so I can see it. Very good. All right, Mr. Zorn, anything else?
No, Your Honor. Thank you very much. We appreciate the hearing today.
You're welcome. Mr. Nosage, anything else?
Nothing from us, Your Honor. Thank you.
Mr. Eoff, Ms. Eoff, anything else?
No, Your Honor. Thank you for your time.
All right, you're welcome. All right, thank you all. It's good to see all of you. I wish you a very happy rest of the day, and we'll look forward to seeing you again in the future. You may be excused, okay?
It's been a pleasure seeing y'all today. Thank y'all.
Yeah, the judge has to handle that one very carefully because he's got some protections under the First Amendment with being a church. So yeah, that's the only reason that they're able to get away with selling their sacrament the way that they are and with what it contains. Hey, Ichidaskatum. Yeah, to well, okay. A short recap is that the crazy guy lawyer called the defendants who are represented by legal counsel. You can't do that. Once someone retains an attorney, you can only speak to them through their attorney. That's the point of having an attorney. It builds a wall, and you can't cross that. He crossed it. And not only did he call them, but he called them pretending to be someone else. And but he doesn't remember it, y'all. And then he pretended to be trying to get donations for the church or something. His wife heard him pretending to be G, but she didn't hear him the other time. But he admitted that, my wife heard I did it. Basically, he's on thin ice. Like, he's lucky the other attorney didn't, pursue it a lot harder. Because if the other attorney wanted him to lose his law license over that kind of conduct, he kind of could. The primary ingredient in their sacrament is magic mushrooms. Along with a couple other things. But he claims it's not. He claims that that's just kind of one of the components of it, sort of thing. But the other side did testing. And the testing showed that that's what it was. Now, here's the funny thing. I'm not sitting here saying, drugs are bad, don't do drugs, blah, 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 blah. I've heard a lot of people who have had relief from debilitating migraines through the use of psilocybin and other medical conditions. It does have medical properties. I'm not advocating to do it. I don't do it myself. But if someone finds legitimate medical benefits to it, from it, I support you in relieving your pain in a safe manner. What I'm not okay with is selling and marketing something as one thing when it's not. Because here's the thing. Some people are randomly screened, urinalyses. And if something like that shows up in a screen, when you thought it was something else, suddenly you lose your job, or if you're on a medication contract, all your meds are pulled from you, or so many repercussions can happen from that. If it has it in it, you really need to tell people. That's my biggest beef. That's my biggest problem with it. Well, not kids necessarily. I don't know who is a member of their church. I don't know who's a member of their church. But it's being sold as a religious sacrament. It's you know, you know how Catholics will drink their wine and have their bread. It's kind of like that for their church, but it's made by a chemist or discovered by a chemist. Exactly my point. That's my problem with it. If you met him on the street and he somehow convinced you to join his congregation and be a part of his members that give him over $100,000 a month to do what he does, and you thought that you were just having a water into wine kind of moment with the church, and it ended up being something that cost you your job, that's not okay. It was not necessarily a lawsuit where that they were seeking anything as far as damages go. The lawsuit was essentially trying to put a stop order into place that makes it so the guy recognizes that he's not allowed to call the defendants directly. He has to go through the lawyers. The judge had stated that she had never, in her 30 plus some years of being, you know, an attorney or judge, she'd never seen that motion used. And the motion was basically just saying you're violating local rules, local laws, and you need to stop it. They didn't want anything as far as a judgment goes, because they didn't want to hurt the guy. They just want him to behave, you know? It was like they wanted the judge to say, you're doing something wrong, knock it off. But they didn't want him to be punished yet. But if he continues his behavior, it's kind of like they wanted to leave a trail that the court could follow and say, okay, you knew the rules because this was explained to you on this date. And you kept doing X, Y, Z. Yeah, one of those motions. I think there might be litigation in progress for that. And yeah, that's kind of what this stemmed from. But this isn't that. You know, I believe there is a litigation because of that claim. Now, I don't know the story of which side filed what against, you know, who did what to whom. I don't know. I walked in at the point you guys walked in, basically, you know. I saw that guy and went, what am I watching here? And what is this? What is he on? You know? Something chemically manufactured on a cow pie. That's what it was. So, I know he was, like I said, he was doing stuff that could have cost him his license. You can't do that. You're an attorney and a First Amendment expert. You should know those rules. Oh, y'all, I gotta go get Ava. She's going nuts. She's going nuts. All right, this next one, you can't be mad at me. The judge turned the camera off before he gave his ruling, but it's still entertaining. It's still entertainment. And we'll just have to make up the ending ourselves.
Afternoon.
Good afternoon.
Good afternoon. Am I not on Zoom?
Now you are apparently on a telephone.
Well, I went to the main office when I picked up my paperwork, and I asked them how to do Zoom. It doesn't seem like anyone in our circle knows how to use Zoom. So they told me to call a number. I've got about 6 here. And then it shows courtroom 8, passcode 3, and
Right.
the Zoom meeting ID link.
Okay, if you called in on a telephone, you're not going to appear by video. Do you have something that would allow you to appear by video?
That's all I have. I don't have a computer. I'm very sorry, Your Honor, because you did ask me
No,
to
that's
please
okay.
be on Zoom. And I went,
That's all
I
right.
actually, okay, but I did go to CAP.
Yeah.
I also asked them how to do this, and they gave me the same instructions.
Do you have a computer with a camera on it?
I have an iPhone.
Right.
We're seniors in our late 70s. We don't know how.
We'll just make do with the way that you're appearing right now. That's fine.
But that's a shame because I went to a lot of trouble to look decent.
Yeah.
Anyway.
Oh, that's okay. Okay, so we are here on small claims case numbers 24S083. We are here for trial. Present, we have Esther Elston.
Yes, sir.
And we have, is it Christopher Fry for Columbia River Properties? Is that correct?
Yes, sir.
That's correct.
All right. Let's see. I have documents that have been submitted by Ms. Elston. I don't have anything for Columbia River Properties.
Huh.
Ms. Elston, hang on. I'm addressing Mr. Fry. Was there anything submitted?
Yeah, there was quite a bit submitted on Friday to the clerk's office. Two sets, one for Miss Elston and one for the court.
What did you submit?
Say that again.
Oh, wait, maybe this is marked incorrectly. Oh, no, I'm sorry. I do have it. Okay.
Okay.
It's my eyesight. It's not you. All right. So I have one packet from the defendant. Ms. Elston, I've got 3 packets of documents here. One of them was filed on the 28th, which would be the beyond the deadline for submitting documents. Mr. Fry does not have a copy of whatever it is in that packet. So at this point, I'm going to be proceeding without that information. Is it crucial for your case?
It is crucial for my case because what happened was I'm disabled and I had to have help getting up to the office to turn in the information. And when we got back to the vehicle, we realized it was 4:30. Your offices are closed and part of the information had been left behind. Mr. Fry, what I gave him is on, I texted it by text. It stated that I could put it in writing or by text.
Let's see what it is. This is a letter dated May 15th to Mr.
Mhm.
Fry.
Mhm.
Mr. Fry, did you receive a copy of this letter? You know,
I'm not certain what the letter is, to be honest. A
It's
letter
been
dated
texted.
the 15th.
May 15 of this year. Starts out, I am writing you to dispute all charges assessed against me.
Is that the one that is on our Columbia River property letterhead with?
No, it's a handwritten letter on lined paper.
I did not receive that. The only letter I see is dated August 11th of 2023.
Well, Miss Alston, I think that we could probably do without that. You have the
Okay, sir.
ability to testify. So, okay, so I have 2 packets from plaintiff. And Miss Elston, all the other stuff, you've provided 2 copies and Mr. Fry has received those. Is that correct?
I believe so.
Yes, sir.
Mr. Fry, you have copies of photographs and so forth?
Yes, sir.
Okay. All right. We will go forward with what we've got. Some ground rules for our trial. The way that I proceed, Ms. Alston, you will have an opportunity to testify first.
All right.
When you're testifying, if you are referring to any document that you have submitted to the court, you need to specifically identify that document so that I know what you're talking about. Okay.
Okay.
It is important that you actually both you and Mr. Fry realize the fact that I know absolutely nothing about this case. And I'm relying on what you say to inform me so that I can make a decision. Okay, so it's important that you don't assume that I know something about it. All right.
All right.
And
Do
I direct each party to make sure that any comments that are made directly to the court. You are not to be addressing the other party. Okay.
Yes, sir.
Any questions from either one of you before we get started?
No.
Oh, okay.
So,
Questions, Ms. Fry, Ms. Elston, we will start with you.
okay.
If you would raise your right hand, tell me when it's raised.
It's raised.
And you swear to tell the truth in this proceeding.
I swear to tell the truth before God in this proceeding.
Okay. Then if you would please state your full name, spell your last name for the record.
My full name is Esther Michelle Elston, Elston.
Okay. And you may go ahead with your testimony.
All right. Now, my testimony is as such. We were asked to vacate the premises. I'm looking at my paperwork and find out the exact date. But we lived at the premises for 3 years. I never missed rent. I always kept my apartment immaculate. And we got a letter from Mr. Fry telling us that he would not renew our lease. Excuse me.
When did you receive that letter?
When did I receive it? If you don't mind, sir, I have a ton of paperwork on my lap. Can you give me 1 minute?
Yep.
Okay. There is so much paperwork. 60 days. Okay, here we go.
And do I have a
It was,
copy? Do I have a copy?
I have it.
Do I have
I
a copy of that letter?
Well, it was from Columbia River Properties. I imagine you do. 60-day notice to terminate.
Did you submit a copy of the letter in your packet?
I did.
Okay, let me see if I can find it. Okay, is this the letter? It's dated August 15? 60-day notice to terminate tenancy?
Yes.
Okay, go ahead.
So when we were told to terminate and vacate the premises, we were somewhat shocked because we are seniors living on a limited income. And when this happened, we had to rent storage units, and therefore it put us in a situation since Mr. Fry had told me verbally on the phone he was not returning my fees, for deposit. Anyways, we ended up in a homeless shelter across the street because we did not have the money to rent. And then to make matters worse, the amount that Mr. Fry was demanding, let's see, I'm looking for it, it was close to $3,000. It was so ridiculous. And we left that apartment immaculate. When we moved in, it was surfacely clean. But the gentleman that had lived there was 100 years old, had lived there for years, and the floors were filthy. The kitchen floors were cracked and black. And the bathroom was filthy. We found feces between the toilet and the bathtub. And I noticed from the paperwork that I received from Columbia River Properties, pictures that Mr. Fry or his whoever took, shows pictures of the ceiling in the living room being dirty. And I'm thinking to myself, how would we get the ceiling dirty? We never used the fireplace. The carpeting when we moved in was infested with ants. So we had to use borax. It took 2 months to kill the ants. It took 3 years of cleaning those floors to finally get them to where they were white. We don't know why we were evicted. I call it an eviction, that's what it is. Because our governor passed a new law that states unless you have a really, really good reason to terminate somebody's vacancy, you better have a good reason. And the reason it took me this long to finally file is because when I ended up across the street at the homeless shelter with my husband, they had an infestation of COVID. And I immediately got COVID, which turned into pneumonia, and I was sick for 6 months. And I believe and feel that all this were the actions of Mr. Fry kicking us out, putting us out to the streets. And that's exactly what he did. He told me on the phone, oh, I called to tell him I was replacing all the blinds. He told me not to. And he said, I'm not giving you back your deposit. My husband sat next to me. I had it on speaker. He made it very clear he would not give me my deposit back. So there was quite a bit of animosity between Mr. Fry towards myself, and I sent a registered letter requesting all documentation that had taken place in the 3 years that we lived there between myself and Mr. Fry, because he had consistently harassed us. He threatened to evict us over a bowl of dry cat food that was out front. There were tenant cats on the property, and one of them was starving. And he told me if I did not get rid of the cat food within 10 days, we would be evicted. And this was at the height of COVID. And that's just one of many, many, many things. We were harassed consistently, and that is why he never forwarded any of the mail.
So you were feeding stray cats on his property, and he asked you to stop because it was drawing more cats. That sounds reasonable to me. I love cats. I personally will feed them, but I own my property. But if a landlord tells you, I don't want you feeding feral cats because it's drawing more cats around, yeah, that's a legitimate complaint.
Okay, so you're here to recover your deposit. Is that what you're asking for?
Deposit and maybe penalties. When you turn in false information to damages someone, isn't that called libel or libel? And that's exactly what Mr. Fry did. He falsified information to the tune of almost $3,000, stating we had damaged the apartment, which was in much better condition when we moved out than we moved in. And it caused my credit score to dive 70 points when he did this, which made it almost impossible to rent anything. Who does that? And then I called Mr. Fry to tell him that one of the tenants had been throwing feces at our front door. His answer to me was, well, I can't blame them. Who says that?
Listening.
Oh, that was it. I was waiting for an answer. I'm sorry.
Okay. So you originally rented the apartment in 2019, is that correct?
Yes, sir. Yes, sir.
Okay.
We never missed rent. We were never late. The apartment was always clean. Oh, yes, I forgot to mention in the back bedroom was moldy. There was something that was never brought up.
Okay. Do you have anything else?
Not at the moment.
Do you have a pet?
I have two pets. So we got doctors' permission. We got doctors' written notices that they were comfort pets, and they're precious. They're absolutely docile, and they're our bed companions. They sleep with us. My husband has his, and I have mine.
Okay. Okay, so do you have anything else that you want to tell me?
Let me think. I'm looking back in my mind at all the charges that were assessed against me by Mr. Fry. I know that the refrigerator that we had used was cracked. I'm not saying that it didn't work, it did. But it seems to me that we were being blamed for the condition of it. When we left, it was immaculate. We are being charged for pans, the metal pans that go underneath the metal burner. We'll be charged for replacement of those, which is ridiculous. I not only cleaned them, but I put foil under them so nothing would spill. When we moved in, I'm not, pardon me?
The photos that you've submitted,
Mm-hmm.
are these photos, when did you take these photos?
After we got done cleaning,
Okay, so this was the condition when
after
you moved out?
condition when we were moving out.
Okay. All right. Very good. We'll hear from Mr. Fry. So Mr. Fry, if you would please raise your right hand. Swear to tell the truth in this proceeding.
I do.
You would please state your full name, spell your last name for the record.
Christopher Wendell Fry, F-R-Y.
And how are you related to Columbia River Properties?
I'm the president of the corporation and the designated broker.
Okay. So I guess that gives you authority to represent the corporation.
Unfortunately, yes.
Okay. You may proceed with your testimony.
Okay. I think the tenancy dates are correct, as Ms. Elston stated. We provided her, you can see my opening statement is that we were hoping that Ms. Elston would try to resolve this without coming to court. She never did provide us with any dispute against the charges that we had on our dispositions, but nonetheless, here we are. I would refer, the tenant moved out, we asked her to move out. I don't know if it's really relevant because we're talking about charges against deposit, but since she brought up the issue, we had a number of problems with her tenancy. People living in her apartment without permission. She also had a soft heart for strays and would leave food and water out for feral cats that would come in and do their business in our flower beds. And so after 3 years and many complaints from the neighboring units, we decided it would be best if they moved elsewhere. The property condition report is under exhibit, let's see, A towards the back. And I would note that we give all tenants 14 days after they move in to make any amendments to the property condition report. We do realize that we are not always 100% accurate when we do our version of it, so we give the tenant some time, 2 weeks in fact, to make additional notes to the property condition report and then submit it back to our office. And that's what we refer to when they move out. The biggest charge on the disposition is painting, and I have provided many photos. If you also notice that we had painted the unit prior to them moving in. And I have about 15 different pages, which are listed on page 2, of various photos of different rooms, a lot of patchwork, nail hole patches that they attempted to do, which essentially left us with an apartment with looked like a spotted pony. There were so many that it required us to do a full paint of the unit rather than try to touch up paint, which is sometimes possible when there's only a few nail holes. Most of the blinds were damaged, primarily we assume from her emotional support animals, because cats often want to sit in windowsills. She may have had a conversation with me regarding the blinds. They were damaged. We didn't say that she wouldn't be charged for them, but I did say that we would be replacing them. I did tell her that she couldn't replace them, but that's how we got the property back. The other thing I would point out to the court is I'm well aware of Miss Elston's financial situation. She lives in low-income HUD housing for seniors. I know that she does not have probably enough money to pay what we think is owed. We have written off the debt. We don't expect to get paid by it. But we do believe we have enough evidence to retain her deposit since the charges exceeded the deposit amount.
Well, it was the cats.
We would propose that we are able to retain the deposit. We will forgive the debt owed and reduce collection since we don't think we would be able to collect it anyway.
Honestly, I think Karen should take the deal and run.
I provided our move-out inspection report. I just provided the items that were relevant to the charges on the disposition. There's 122 pages. I thought it'd be too cumbersome to provide the entire report, although I could if somebody thought it was necessary.
Okay, I'm sitting here looking through the multitude of photos that you submitted. I want you to point out something to me that is beyond normal wear and tear after a 3-year lease.
Okay. We'll start with, I guess, painting, because that was the primary or the largest part of the repair bill. So I would refer you to page 11. It shows to the left of the front door, discoloring on the walls. Page 16, discoloration underneath the window, and you can see the nail patch marks above the window. Those were not there prior to her occupancy. Page 17 shows a couple discoloration marks on the walls. 19 shows damaged blind. 27 shows multiple patch marks, actually quite a few above the window and below the window. 28, several patch marks and discolorations.
Okay. Other than the patch marks, what would be beyond normal wear and tear?
No, let me look at the disposition again. Rescreening the storm door, replacing the damaged blinds, living room and dining room, the drip pans in the stovetop. Those were, it's actually less expensive to replace them than try to clean them to be honest. The pets or ESA animals damaged the carpet primarily in the hallway at the entrance of the bedrooms, which by digging at the corners of the entryways to the 2 bedrooms. Then we had two damaged screens and 2 bedroom blinds that had to be replaced.
Isn't it standard practice for at least property to be painted, freshly painted after the tenant has moved out?
No, it just depends on what we're left with.
Well, I mean, after a 3-year lease.
A 3-year lease, well, I consider normal wear and tear as, let's say, furniture rub marks on the walls from, say, a sofa, scuff marks in a hallway from, just traveling down the hallway. But I think nail holes and patch marks are purposeful, and I don't think that is normal wear and tear. But of course, that's my opinion.
Okay. And anything else?
No, other than I believe everything we listed on the disposition was above normal wear and tear.
Okay. And how do you distinguish then the difference between a security deposit and a damage deposit?
I didn't know. I'm not sure that I understand your question.
But you generally have a security deposit and or a damage deposit. I'm looking at your lease agreement.
Mm-hmm.
And it's indicating a security deposit of $750. So how do you distinguish between just a security deposit and a damage deposit?
Well, we don't charge a damage deposit. I believe it's one and the same.
Okay. Okay. Do you have anything further?
No, sir.
Right. Okay. Ms. Elston, did you have any last minute comments that you want to make at this point?
Yes, I do. Please scrub those walls with Murphy's Old Soap from top to bottom. The reason my husband put spackle in the holes is because they were there in the first place. We spackled the entire kitchen seams by the faucet. It was a very long counter. He did all that. He repaired that. He repaired everything in the bathroom that hadn't been done, that should have been done. He repaired the bathroom, bathtub where there needed to be, the seam needed to be spackled. Is that what they call it, Lottie? Spackle. We cleaned that place inside out. By the time we moved out, the floors were white. I saw a picture that the gentleman, handed in, and it shows an area in the bathroom that looked like it was bleached or I don't know, but those floors were black. We were rented an apartment that should have had new flooring. It did not. It should have had new carpeting. We had an infestation of ants. As a matter of fact, I had ants in my bed. They weren't, huge amounts of ants, but maybe 5 or 6. Then we found out in the wintertime that we didn't
Some of the things that you're mentioning are issues that may have been issues, but they're not necessarily relevant to whether or not you should receive your security deposit. Those are things that I guess potentially could have been brought up during the tenancy. Now, my question, I guess, for you is, did you do a walkthrough after you moved out with the landlord?
No.
Okay.
We've never heard of having to do a walkthrough. We had worked so hard on that apartment, we couldn't wait to leave.
Okay. And did you do a walkthrough with the landlord prior to moving in?
No. I just remember driving down the street and seeing this beautiful green belt in between the two buildings with trees and flowers, and they had ponds and birds, and I thought, I want to live here. It's beautiful.
Okay.
That was it. And so I went in and paid my deposit and moved in. Didn't do a walkthrough. We could have, and maybe I don't remember. I just don't remember. That's the truth.
Okay.
But I would like to make one more comment. The homeless shelter where we were staying was directly across the street. And when we left the apartment, we left all the blinds wide open up and the light on, so the snoopy neighbors could see how clean the apartment was. And my next door neighbor, number one, Victor, asked us if we had painted the whole place over. We said, no, we cleaned it. And I can tell you for sure that I never saw anybody go over there and paint. But we checked every single day, and I never saw any carpeting being brought in.
All right. And then Mr. Fry, I do have a question for you.
Okay.
I'm looking at, what am I looking at? This appears to be the property condition report.
Yes.
Looking at page 3 and 4.
Okay.
Need you to look at the signature date on it. Tell me when this was signed.
It's 10/31/24, which is not correct. The front page says 10/31/19.
I'm looking at page 3 and 4.
Yeah, I know. Yeah. 10/31/24 is what's stated there.
You know when it was signed?
I do not.
And whose little scribble is that?
That is my initial.
Okay. All right. Let's see.
And that's where the judge took it down. It's not that I didn't get the whole thing. I got the whole thing. But that's where the judge ended the live stream. But yeah, I wanted to share that with you for, the entertainment value, of course. But also it had some really good property lessons. Always take pre-occupancy photos and post-occupancy photos with the date turned on the photos. Thank you. You make a better door than a window. So yeah, always make sure on your camera, how you can set the date, do it and make sure that the date is visible on the photos. Or take a video. Absolutely. Do something that gives you proof of the conditions as they are from when you move in and when you move out. Especially, this is to protect you. And the same goes for property owners. There's no reason you can't do this stuff too, I am on the guy's side. And by the way, that whole big fit that Earl was having earlier, that Timmy fell in the well kind of emergency tone that he had. His toy died and he needed it plugged in. That was the emergency. The toy he got from Checks and Cherries, the battery died. He was very upset about this. So it is charging now. Hopefully he'll be okay. He'll be okay, buds. I promise. I'm I am pretty sure. She was a little much. You know, guy number one was a bit much. She was a bit much. Yeah. And now Billy's playing with the toy. Now they're both hitting it up. I just saw TCC went live. You are going to break this, and I don't want it broken. Thank you. You can go back to playing now. You can go back. Yeah, go back. That's my... Okay, fine. I know where this is going. I know what's going on here. Don't think I'm stupid. Don't... Well, one of y'all's got to get over on this side, because the other one's going to come on this side, and you know how this is, Lady and the Tramp style. Yeah. They were waiting for this. I can't give one individually, because if the other one notices, then boom, they're right here. You guys are too funny. You're too funny. Oh my gosh. Whose idea was this anyways? Earl came with these. When I got him, he came with these in his little goodie bag of food and stuff. This isn't something I started. His previous owner did it. Her name was Sandra. Every once in a while, she comes in the chat to say hi. And to see her baby. My grandbaby boy. Yeah. Is that good stuff? This is salmon flavor. This is salmon flavor. Yes, Chadaskidum. That's kind of why I still ran it, as I was like, okay, well, we can all guess on what happens. Well, get that big old glob from my hand, please. Thank you. You got some on your nose, Billy. Earl will get it. Okay, hold on. Let me squeegee this. Let me squeegee it. There you go. Right here. Billy. Right here. Or Earl. Somebody come get this. I just got to get that glob off your nose. Thank you. You can have it. I don't want it. I just wanted it off your nose. I know. Jenny Green, you are so right. You are so right. The toy, the battery dying on the toy, that is an emergency. That is, you're right. It definitely needed to be managed now. Because, you know, it takes a few hours to charge. Hi, Jody Gardner. Oh, thank you, Chadaskidum. I'm sorry, guys, that I can't put comments up on at the moment. I had to finish with the kitties, and I had to get the salmon off my hands. Thank you. It has sheer sleeves. I love it. And it's got diamonds. These are, I know they're not real diamonds, rhinestones. It's got rhinestones on the sleeves and on the neck. Yeah, it's pretty. I like it. I love it. I want some more of it. Oh, yeah. It is getting warm. I need to turn on the AC soon. Yeah, that is the sweetest thing, Chadaskidum. I'm so happy that that you're providing love to a kid. You know what? That's the best unconditional love there is from a child. They don't know any different. Love you too, Jody Gardner and Papa Les. I love you. I hope you guys are both having a great day. I have been being stingy. I could turn it on. I should turn it on. But no. There. Oh, my hair just doesn't want to do anything. It's so humid out, and my hair is not cooperating. It just wants to, curl up and frizz up and go every which way, and I'm not happy about it. It doesn't look good. It looks bad. There. Now it looks okay. If I don't touch it, if I don't move, it'll be okay. I don't know. We can get my friend Nicola Maxwell back in here, and she'll say if it's too hot for a Scott. The animals? No. Well, I guess I have to correct myself on that. They would probably, if I gave them the opportunity to, but I don't watch TV. So no. I watch court dockets all day long in order to find cases to stream for you. And then once I find them, I edit them. And then I'm here. I used to, my previous cat, Crow, he and I would watch Burger King live together. And we always loved that. Mutually loved that. Hi, Ava. Oof, she just pushes me right out of the way. She doesn't care. Thank goodness my chair is a spinny chair. Hi. What you doing? What you doing, girl? What you trying to say? Yeah. Thank you so much. I love it. Birder. Birder King. It's a show with, you know what? Give me just a second. All right. So he sets up a little station. And this is what you see for 6, 8, 10, 12 hours or more. You know, I mean, it's just naturistic things. Sometimes it's in a park, sometimes it's in the woods, sometimes it's on a railing. It's so cute. It's so stinking cute. And sometimes you get to see, you know, them making calls to each other and play and interaction and the different types of wildlife depending on where he sets it up. I'm sure if I put this up on the big TV, they would, but Billy's a hunter. I am very much afraid that he would break my TV. I remember Crow, and Crow came close a couple times. He would do the butt wiggle back by the door and then launch. But this is great to put on if you've got pets, even if you don't, if you just need something to help you relax. The nature sounds are so relaxing, so soothing, and I just love it. So yes, the channel, I'll put a link, but it's Birder King, not Burger, Birder. So I just love it. And the squirrels are so cute. But I have them in real life every day. Yeah. Oh, I'm so sorry. Well, now you have it. Yep. Just type that into the YouTube search bar, and that's what you find. And he's got hundreds of videos. It's amazing. Whoever it is, oh, they've done so well. They have done so well providing entertainment for animals and, you know, lonely housewives alike. You know, when you got nothing else to do, but you know, and here I don't have a nature scene. I have at previous homes that I've lived at, I've had very naturistic property, but not here. I'm in between two houses, and you know, I've got big, you know, concrete driveway in my backyard. I don't have a lot of yard, really. It felt like a lot more when I gardened, but now that I'm not able to garden, it just doesn't feel like much of a yard at all. And like I used to put bird feed and peanuts out on my handicap ramp every single day. I would just line with bird seed, but right now I can't afford to do that. Someday, I really hope I can. I think he should video Imposter Steve and then make his own channel of the whole imposter family. Oh my goodness. Sorry guys, I forgot to turn my ringer off. And it's not Emily. let's see. Oh, the live stream just ended. Give me just 1 second here. Hopefully they don't take it down right away. I got to take that call. My brain stops working and I forget what steps I need to take to make happen what I'm trying to make happen. Okay.
Mr. Dale.
Where's the lawyer at? Where's the lawyer at? You can't talk before court or what? Guess not. Gabriel Wilson. I ain't been here a long time, so I'm expecting to get released. I've been out of trouble for a long time.
You're a mystery.
I deserve to get released. It's only right. I'll come back to court. I've been out of trouble for a whole year already. Come on now. Right thing. DA ain't got nothing. All they got is a cuff word over mine.
All right,
sir, what is your full name?
Gabriel Wilson.
I have this wrong. Okay, Wilson, 103. I've got the wrong. All right.
All
right, Mr. Wilson, you are here because you have a charge out of Tucson City Court of possession of drug paraphernalia, and you have a second case in city court where you're charged with disorderly conduct and criminal trespass, and you have a third case in city court where you're charged with disorderly conduct.
That's a very minor, that's like the lead.
You're also, sir, you're also charged with,
charge there is.
sir, you're also charged with failure to appear in one of those three files. I'm going to enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense.
Sir,
I'm going to release you on your own signature on these cases. I'm ordering that you do not go back to any of the incident locations. Your next court date is June 28th at 2:30 in the afternoon at Tucson City Court with Judge Mayhew. If you fail to appear for that hearing, a warrant will issue. You could be tried and convicted in your absence, and if you couldn't be sentenced within 90 days because of your failure to appear, you could also lose your right to appeal. Do you have any questions about your release conditions? Hold on, Jail, you're muted, so I couldn't hear him.
Judge, I've been out of trouble for a long time. I don't even break the law the way I used to.
I'm just asking that you come back to court on June 28th and that you don't go back to the places where these incidents are alleged to have occurred. Do you understand?
There's plenty of places I can go.
Okay,
do you
understand?
You understand you need to come back to court?
Place of the crime, I know.
Sir,
I know I
do you
gotta come back to
understand you
court.
need to
Yes,
come
I know I
back to
gotta come
court
back to court. Yes.
June
June 28th at 2:30?
All right.
Put me in the mental health court. Sign me up for mental health court.
If
you want to be in mental health court, make sure you let them know when you go to court on June 28th. Let me put a sticky in there. So health court, question mark. I just want to have a longer conversation with him tonight. Let the judge may feel. It's clearly agitated. Okay. Then Robert Dale is the one who's in the hospital, correct?
Yes, ma'am.
Okay. And is he being held on anything other than the city court cases?
And a superior court hold.
Ah, okay. I am debating doing it.
See, because we've just been continuing them for like days now, and it's people that just building. I don't know if you can still conceive of this stuff.
Oh, shoot. Can I have back the one I just gave you?
Yeah.
All
right, here's what I'm going to do with Mr. Lewis, Mr. Dale. Sir at the jail, just hang tight because I'm going to handle a different case where the defendant's not here, and then I'll get to you next, okay? All right, here's what I'm going to do on Mr. Dale is I'm going to show that he is in the hospital, so he cannot be seen. But I am going to release him on the misdemeanor city court cases. I'm going to release him on his own signature in order that he not go back to the incident location. I'm appointing Jeff Grinkowicz as to be his attorney, and I'm putting Mr. Grinkowicz's phone number on the paperwork so that he can get in touch with him. And I'm noting that arraignment has not been completed on this case. He needs to be arraigned at the next hearing. So the next hearing will be an arraignment. All right. And then that way we don't have to keep doing this twice a day because I'm not holding him, so he should be good. Okay. Sir at the jail, what is your full name?
Nicholas Connor Peterson.
All
right. Mr. Peterson, you are here because you've been charged with possession of drug paraphernalia and driving on a suspended license. I'm going to enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense. Sir, you're being held on a felony charge, and I am not seeing you on that. I'm only seeing you on the misdemeanors. On the misdemeanors, I'm going to release you on your own signature in order that you do not drive unless you have a valid driver's license. I'm appointing the City Public Defender's Office to represent you. Sir, your next court date on this is June 28th at 9:30 in the morning with Judge Hale at Tucson City Court. If you're still in custody on the felony, your attorney will handle that hearing for you. But if you're out of custody, you have to appear for that hearing. If you're not there, a warrant could issue in your absence. And if you couldn't be sentenced within 90 days because of your failure to appear, you could also lose your right to appeal. Sir, do you have any questions about your release conditions?
No.
All right. Good luck, sir.
Thank you.
I love this court. I really do.
All right, Jill, do I have it correct that Mr. Rogel is next or no?
Yes.
All right, thank you.
Sorry about the echo. That happens often here.
Hi, sir. What's your full name?
Tobias Michael Zelle.
What are you doing? I'm sorry. What's your full name?
Tobias Michael Zelle.
Oh, I thought Rogel was next. Okay,
Judge,
yes?
we could just do him quick. He's a felony, and then he'll go back to a bunch of misdemeanors.
Yeah, that'd be fine. I just was told that that was the order we were going to be in, but I'm confused. All right, so you are Tobias Jose. All right, sir, you are here because you have been charged with promoting prison contraband. I will enter a not guilty plea for you. You have the right to remain silent and the right to an attorney. I'm appointing the Public Defender's Office to represent you. Sir, because you're charged with committing an offense while on release for another felony offense, I'm required by the Arizona Constitution to hold you without bond. I will hold you without bond, and I'm ordering that you have a no bond hearing on June 3rd at 2:30 in the afternoon. I'm also setting a preliminary hearing on June 10th at 1:30 in the afternoon. hearing on June 3rd, which is the no bond hearing, should happen as scheduled. However, the hearing on June 10th is very likely to change. So if the judge releases you after June 3rd, make sure that you stay in touch with your attorney. If you're released to pretrial, stay in touch with pretrial as well, because that court date may change. And if they can't get a hold of you to tell you when your court date is, then you miss it and get a warrant. Do you have any questions about your release conditions, sir?
Well, yeah, I was scheduled for a hearing tomorrow.
That's on a separate case, sir. You'll still have that hearing, but now you have another case that's going to be set for a separate hearing. They will eventually get consolidated, but not right away.
All right,
All right, good luck, sir.
Yeah.
We'll talk to you.
Go ahead.
Yes. Well.
Hi, sir. What's your full name?
Marcelo Rojo.
All right, sir, you're here because you have a warrant out of Marana Municipal Court. It looks like you failed to appear on a shoplifting charge. I'm going to release you on your own signature in that case. I'm ordering that you do not go back to the incident location. I'm going to enter a not guilty plea. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense. Sir, you're held on a felony charge, and I am not seeing you on that. But because you're in custody, I'm going to set a hearing tomorrow at noon with the judge in Marana so that you can talk to her about your case. Do you have any questions about your release conditions?
No, ma'am.
All right, good luck, sir.
Your Honor, well, it looks like Campos refused.
I'm sorry, who refused?
Garcia Campos.
Okay. That is number 10.
All right.
So the interpreter, that's the only Spanish speaker, correct?
Yes.
All
right. So Mr. Garcia Campos refused. The interpreter is excused, and this will be continued to the morning.
Okay. Thank you, Judge.
Misdemeanor, stand up.
Let me see through the sleep. It's on the.
Yes.
Now comes misdemeanors. Yay!
Oh, shoot, I just signed. Sir at the jail, what is your full name?
Hello, Jordan Joseph DeLucia.
Which number is he?
That's 2.
2. Okay. Somehow this one, oh, this is the one that refused. I'll come back to that. Okay. All right, sir, you are here on a couple different things. First of all, you have warrants out of Tucson City Court. You failed to appear on charges of shoplifting, criminal trespass, failure to appear, shoplifting, failure to appear, shoplifting, failure to appear, failure to appear, shoplifting, failure to appear, and failure to appear. On those charges, sir, you have the right to remain silent and the right to an attorney. I'm appointing the City Public Defender's Office to represent you. I'm setting bond in the amount of $250 secured and ordering that you do not go back to the incident location.
I notice a pattern, and I am not referring to his male pattern baldness.
Sir, your next court date is June 7th at 1:45 in the afternoon, and you'll be seen by video then. If you're released from custody before then, your court date changes to July 15th at 9:30 in the morning. You must appear for that hearing. If you're not there, a warrant could issue. You could be tried and convicted in your absence, and if you couldn't be sentenced within 90 days because of your failure to appear, you could also lose your right to appeal. You also have a warrant out of Marana City Court for failure to appear on shoplifting charges. On that, I'll enter a not guilty plea for you. You have the right to remain silent and the right to an attorney, although not necessarily at court expense. On that case, I'll release you on your own signature in order that you do not go back to the incident location. Because you're being held by city court, I'm setting a hearing tomorrow at noon with the judge in Marana so you can talk to her about your case. You also have a warrant out of Pima County Justice Court for failure to, nope, sorry, I take it back. You have new charges out of Pima County Justice Court. Or they are shoplifting, trespassing, resisting arrest, and possession of drug paraphernalia. On those, I'll enter a not guilty plea. You again have the right to remain silent and the right to an attorney, although not necessarily at court expense. I'm going to release you on your own signature in order that you don't go back to the incident location. Again, because you're being held by Tucson City Court, I'm going to give you a court date tomorrow at 1 o'clock in the afternoon with Judge Ball from Justice Court. So you'll see two judges by video tomorrow. If you get released before then, you have to appear for those hearings or a warrant could issue. And then you'll see the Tucson City Court judge on June 7th if you're in custody and July 15th if not. Do you have any questions about your release conditions, sir?
No, ma'am.
All right, good luck, sir.
Thank you.
Edwards, just have a seat out there, bud.
That's right here.
Yeah. Back out there in that far corner.
Hi, what's your full name?
William Toby Edwards.
All right. So you're here on a number of things. First of all, in Tucson City Court, you have new charges of criminal trespass. You also failed to appear on charges of possession of drug paraphernalia, possession of prescription-only drug, and being in a park after hours. In that case, you're also charged with failure to appear. I will enter a not guilty plea for you on those charges. Sir, you do have the right to remain silent and the right to an attorney, although not necessarily at court expense.
Thank you, Your Honor.
Give me one moment to finish reviewing your files.
I thought that was a woman when they first came in. I did. I got that one wrong.
It looks like you were recently placed on probation in Tucson City Court. On this case, I am going to set a bond of $250 secured. I'm ordering that you do not go back to the incident location. I'm appointing the City Public Defender's Office to represent you. I accidentally scratched out the video review date on a new Hale, but it's a video review.
So June 7th. That 145.
All right, sir, your next court date on this case, if you're in custody, will be a video review on June 7th at 1:45 in the afternoon. If you're released from custody before then, it changes to June 28th at 9:30. You must appear for that hearing. If you're not there, a warrant could issue. You could be tried and convicted in your absence, and if you couldn't be sentenced within 90 days because of your failure to appear, you could lose your right to appeal. I see you raising your hand. I am not going to change the release conditions and let you out. You were literally just placed on probation in February, and you have a very long history of failure to appear. If there's something else you want to tell me, I'll listen, but don't talk about the charges because anything you say can be used against you.
Yes, ma'am. I was released from jail, and I was picked up yesterday. In my opinion, I thought for reasons unknown. I just don't understand what the heck's going on because I was supposed to from the charges before, I was supposed to, I was serving my sentence.
Right, but you have new charges. So that's why you're in custody again, is you have new charges. You need to deal with those with your, I'm giving you an attorney to help you figure those out, okay? Then, sir, you also, hold on, you also have 3 warrants out of Pima County Justice Court for failure to appear on charges of shoplifting, failure to appear, criminal trespass, resisting arrest.
Those are the ones that we've already been seen for, Your Honor.
They're not resolved cases. You have not resolved these charges, and you are failing to appear and getting warrants.
I had set dates to have those to be looked at. Okay, I'm trying to get a job. I'm trying to get my stuff together.
Sir, hold on. I understand what you're saying. I'm not going to release you. The law requires me to set release conditions that assure your appearance in court. And I don't believe that you will come back to court if I release you on your own signature.
Yes, I will, Your Honor.
Sir, I'm not changing my ruling. Can I please finish the hearing? So on the justice court charges, I will enter a not guilty plea. You have the right to remain silent and the right to an attorney, although not necessarily at court expense. On the justice court charges, I'm releasing you on your own signature. And because you're being held on the city court charges, I'm setting your court date tomorrow at 1 o'clock with Judge Paul. On those charges, you are not to go back to the incident location. Do you have any questions about your release conditions?
Yes, ma'am.
What's your question?
My question is that I don't understand them.
Okay, well, you have an attorney on the city court charges. You have, and you can talk to that attorney. And on the justice court charges, you don't have an attorney, but you're going to see the judge tomorrow at 1 o'clock. If you have questions about your cases, you can talk to them about that then. But your release conditions are that you are not to go back to the incident location on any of these charges, and you're held on a $250 secured bond.
I don't know what the location is, ma'am. I don't know what I've been charged with.
You're charged in justice court. You're charged with shoplifting, failure to appear, criminal trespass.
Shoplifting from where?
I don't have that information, but you can ask the judge tomorrow. I don't have it because it's a warrant. In city court, I can tell you that you're charged with criminal trespass at 1549 West St. Mary's, so you can't go back there. You're charged with being in a park after hours at 325 North Grande Avenue, so you can't go back there. Any other questions about your release conditions, sir?
I'm out.
All right, good luck, sir.
Am I being released today or what?
Not unless you postpone.
And if I don't postpone?
Then you stay in custody until you see the city court judge on June 7th, and then that judge will decide whether to release you or not.
Oh, man, come on. Sir,
I'm not going to change my mind. You're excused.
How many times did she have to say that? Way more than once.
Hi, sir. What's your full name?
Doin, Dr. Harris.
All right. Hold on. I got the wrong. Your last name is?
Harris. H-A-R-I-S.
Number 3. What happened to number 3?
Really? Just one R?
Did I give you 3 by accident? Oh, 4. Still, I had 5, 6. Oh, here's 4. All right. Sorry, sir. The files are a little out of order today.
All right.
That's okay. Mr. Harris, you are here on 2 things. First of all, you have a warrant out of La Paz County Superior Court on an aggravated DUI charge. You have the, I'm going to enter a not guilty plea for you. You have the right to remain silent and the right to an attorney, although not necessarily at court expense. So I'll be honest with you that I intended to hold you on this. However, I do not have an attorney's name to appoint from La Paz County. La Paz County hasn't provided that information, and I cannot hold you without giving you an attorney. So I'm releasing you to pretrial services on this case. I'm ordering that you do not drive without a valid driver's license, do not have any alcohol or illegal drugs, do not possess any firearms or weapons, and submit to any monitoring or treatment that's directed by pretrial. This is a case where there was a child under 15 in the car. I'm ordering that you are not to have contact with that child and you're not to go to that person's residence or workplace, except you can go back one time with the police to get your belongings. That means you can take my order to the nearest police station and someone will go with you to get your things. I'm ordering that you contact La Paz County Superior Court by 4:00 p.m. this Friday, May 31st, to get a hearing date and that you attend that hearing. They will get a copy of this, sir, if you don't contact them by 4:00 on Friday or you don't attend your next hearing. They will issue a warrant for you. And if they provide the name of an attorney to appoint, sir, I expect you will be held if you're arrested on this again. Do you have any questions about that case?
No.
All right. So you also have a warrant out of Quartzsite Justice Court. On that one, I believe the underlying charge was failure to comply with a court order. I'm releasing you on your own signature on that case. I'm ordering that you contact the Quartzsite Justice Court by 4:00 on Friday, May 31st, to get a hearing date and that you attend that hearing. Again, if you don't contact them and you don't go to the hearing or you don't go to the hearing, you will have another warrant issued. They will get a copy of this, so they'll be expecting your call. Do you have any questions about that one, sir?
No, I'm contacting them. I've been to court the whole case. I've been to court and all that. I just had my son who was born, so I knew I missed court. You know what I mean? I ain't gonna sit there and lie and say I didn't know.
Okay, well, hold on. I don't want you to admit to any new offenses right now, okay? Just make sure. Well, failure to appear for court can be charged as a misdemeanor, so don't worry about convincing me. I'm letting you out today, okay? But make sure that you go to all your court dates so that you don't have to convince another judge to let you out, okay?
Yes, ma'am.
All right. Good luck, sir.
I like him. I know I shouldn't, but I do.
All right, now.
Hi,
what's your full name?
Sierra Lumpy.
All right, you are here, ma'am, because you've been charged with assault as a domestic violence offense. I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense. Ma'am, I am going to release you on your own signature. I'm ordering that you do not commit any acts of domestic violence, do not have any contact with Anton Nehemiah, and do not go to his residence or workplace. If you have belongings there, you can go back one time with the police to get those. That means you can take my order to a police station and someone will go with you to get your things. Your next court date on this is June 28th at 10:30 in the morning at Pima County Justice Court. That's with Judge Steele. You must appear for that hearing. If you're not there, a warrant could issue. Do you have any questions?
No, ma'am.
All right. Good luck, ma'am.
Here. Right there. Wait, hold on, sir. Let me see. Remember.
Hi, what's your full name?
Juan Manuel Reimer.
All right, so you're here because you've been charged with threatening, disorderly conduct, and criminal trespass. I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense. Sir, I'm going to release you on your own signature. I'm ordering that you do not contact Samantha Beamer, do not have any contact whatsoever with Samantha Beamer, and do not go to her residence or workplace. Your next court date is June 6th at 8:30 in the morning at the Green Valley Justice Court. You must appear for that hearing. If you're not there, a warrant could issue. Do you have any questions, sir?
No.
Good luck, sir.
Thank you.
Well, that was short and sweet.
All right, who's next? Hi, what's your full name?
Salvador Antonio Riera Tadeo.
Sir, you are here because you have warrants out of Tucson City Court for failure to appear on charges of assault as a domestic violence offense, disorderly conduct as a domestic violence offense, criminal trespass, failure to appear, criminal trespass, failure to appear, and failure to appear. I will enter a not guilty plea for you on those. You do have the right to remain silent and the right to an attorney. I'm appointing the city public defender's office to represent you. Sir, you are held on a probation hold, and I am not seeing you on that case. So you will remain in custody on that one until you see a judge on that. However, on these cases, I'm going to release you on your own signature. I'm ordering that you do not commit any acts of domestic violence, do not have any contact with any alleged victims, do not go to their residence or workplace. Your next court date on this is July 18th at 9:30 in the morning. If you're in custody, your attorney will handle that hearing for you. If you're out of custody, sir, you must appear for that hearing. If you're not there, a warrant could issue. You could be tried and convicted in your absence. And if you couldn't be sentenced within 90 days because of your failure to appear, you could also lose your right to appeal. Do you have any questions?
Just one, the probation, approximately how long before I'm seen on that? Would you guess?
I don't know for sure. I would hope that you'd be seen tomorrow or the next day at Superior Court, but I don't have an answer to that. I'm sorry.
Okay, thank you, Your Honor.
Good luck, sir.
Thank you.
Aw,
I'll
people
go
are
send
just
that
being
part for you before I let you up.
too nice and well behaved now.
I'm really screwing it up. Did I miss that? No, I did on the ones that were just city, but I think the ones that also had just other things, I forgot. Yeah, I've asked for permission to redo the forms so that we can like have a box for things. It'll take a few months to get to like draft them and get approved by everybody and everything, but I'm gonna redo I've asked to redo the forms for arraignments and IAs. So that we can make sure that information's on. And any other information. So if there's anything else you think should be on there, let me know.
Poor judge. She's trying.
That's what I thought.
All right. While we're waiting, I'm going to take care of Abel Colin because he refused. On that one, I'm going to continue it to the morning session.
Oh.
Very good, Your Honor.
All right.
What's your full name?
18 Lee Walter.
All right, sir, you're here because you've been charged with possession of drug paraphernalia. I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily a court expense. Sir, you're being held on a probation hold, and I am not seeing you on that. You have to see a Superior Court judge on that. On the misdemeanor charge, I'm going to release you on your own signature and appoint the City Public Defender's Office to represent you. Your next court date is June 28th at 2:30 in the afternoon. If you're in custody, your attorney will take care of that hearing for you. If you're out of custody, you must appear for that hearing. If you're not there, a warrant could issue. You could be tried and convicted in your absence, and if you couldn't be sentenced within 90 days because of your failure to appear, you could lose your right to appeal. Do you have any questions about that, sir?
No.
All right, good luck, sir.
That's me.
Oh, he was hurting or something. He even had like the joint going on. You could see it when he was walking up.
Hello.
Hello.
Give me one moment.
While we're waiting, what do you think he's in there for? I'm guessing something driving related.
Sorry, I just need one more moment.
Ooh, we got some guesses going on here, man. Y'all think he's a naughty boy. Oh, there we go. Hello, good morning, Robert from Cologne in Germany.
All right, sir, what's your full name?
Mr. Jacob Carranza.
Defense counsel, do you want to waive reading?
Yes, Judge.
All right, sir, I'm going to enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney. I am appointing the public defender's office to represent you. The pretrial services is recommending that I hold you on a bond. The state is asking that I hold you without bond pursuant to the Arizona Constitution, Article 2, Section 22A1. Counsel, do you want to be heard on that?
Judge, we just asked for a hearing to be held as soon as possible.
All right, so sir, I'm going to hold you without bond. Your next hearing is June 3rd at 2:30 in the afternoon. That is a no bond hearing, and that hearing should happen as scheduled. In addition, I'm setting a preliminary hearing on June 10th at 1:30 in the afternoon. That court date, though, sir, is very likely to change. So if you get released after June 3rd, make sure you stay in touch with your attorney. And if you're released to pretrial services, stay in touch with them as well. That way you know when your court date is. If you miss it, you will get a warrant. Do you have any questions about what I just did, sir?
No.
All right, good luck, sir.
Looks like the public defender is back there again. I know, I missed it. I was trying to see how much time there was left to answer your question, and I missed it. So I don't know who won. But we'll have to play that.
Hello.
Hi, what's your full name?
Mario Brady Verdugo.
Sir, you're here because you're charged with organized retail theft and possession of drug paraphernalia. I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney. I am appointing the public defender's office to represent you. Excuse me. Pretrial services is recommending that I hold you on a bond. Give me one moment to finish reviewing everything that I have in this case.
What's his bond going to be? I say she gives him a PR bond. She likes to do that.
All right, defense counsel.
Judge, we're actually asking that you release him to pretrial services. This is a nonviolent offense. He has verified housing. He's also retired. He's 70 years old, Judge. The bond that the state's requesting for $10,000, they're citing crimes from 1973 and 1987. I think given the circumstances, his age, and these offenses, that you release him to pretrial services. If you're inclined to give him a bond, we'd be asking for a $2,000 bond.
Your Honor, are we talking about Verdugo?
Yes.
Yes.
I have a DOB of Mario Brady Verdugo of 6/20/83. I'm no math major, but that says 41.
Well,
he was convicted
in
1971, so
Good
that
point.
can't be correct.
Good point. Sorry, Your Honor. I didn't
That's
go to,
okay.
I didn't go to law school for math.
Sir, what is your correct date of birth?
6/20/1953. I'm 70 years old. I'll be 71 in June.
6/20/1953.
Yes, sir. Yes, ma'am.
What is going on?
All right, I'm gonna put that on here so that, because clearly you were not born in 1983.
All
All
right.
right.
So
the nature of his criminal history is definitely concerning to me. However, it is very old. It looks like he hasn't been in trouble since 2011, and he's been out of custody since 2012. Given that this is a non-violent offense, and those factors, I am going to release him to pretrial services. So, sir, you're released to pretrial services. I am going to leave it up to them whether it's enhanced supervision or regular supervision, okay?
No problem.
That's what I just asked. So take care of.
All
right, sir, conditions of release, you are not to have any alcohol or illegal drugs, no firearms or weapons, submit to any monitoring or treatment that's directed by pretrial services, do not have any contact with the alleged victim. That means the Big Lots store. You can't go to Big Lots, and you can't go back there, okay? And you can't contact them in any way either. Your next court date on this is a preliminary hearing on June 18th. Oops. At 1:30 in the afternoon. Sir, that court date is very likely to change. You need to stay in touch with the public defender's office and with pretrial services. If you miss your court date, you're going to get a warrant. You understand?
Yes, ma'am.
All
right. Good luck, sir.
Thank you.
I was thinking maybe they meant to pick up his son and they got him, or they grabbed the wrong file, or that's just wow.
1983, and they had prior convictions going back to 1971.
Yeah, I was a little baby in 1983. Could they enforce that? I guess they technically could, but would they? I don't think so, because be giving money and not being on premise.
Oh.
Hi, what's your full name?
Claudia Estrella.
Speaking of which,
All right, you're here on a couple different things. First of all, you have felony charges of burglary in the second degree, trafficking in stolen property, and possession of drug paraphernalia. On those charges, I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney. I'm appointing the public defender's office to represent you. Pretrial Services is recommending that I release you under their enhanced supervision program. The state is asking for a $2,500 bond. Ma'am, I am going to follow the recommendation of pretrial and release you to their enhanced supervision program. You need to do everything pretrial tells you to do, and you need to come to your court dates. Once you've been released to enhanced supervision, the only other option after that, the only thing stricter than that, is to keep you in custody on a bond, okay? So you've got to prove that you can come to court and stay out of trouble. I'm going to order that you do not have any alcohol or illegal drugs, no firearms or weapons, and submit to any monitoring or treatment that's directed by pretrial. I'm ordering that you do not have any contact with any alleged victims and do not go to their residence or workplace. Your next court date on this is June 18th at 1:30 in the afternoon. However, that court date is very likely to change. You need to stay in touch with the public defender's office and with pretrial so you know when your court date is. If you miss it, you will get a warrant. Do you have any questions about that case?
No.
All right, you're also here because you have a warrant out of Tucson City Court for failure to appear on charges of criminal trespass, failure to appear, criminal trespass, and failure to appear. I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney, although not necessarily at court expense. Ma'am, on those charges, I'm going to release you on your own signature. I'm going to order that you do not go back to the incident location, and I'm going to give you a court date of June 28th at 9 o'clock in the morning with Judge Verena. That's at Tucson City Court. Your attorney only represents you on the felony, so you need to come to the city court date. They're not going to remind you. You've got to remember to come to this court date on your own to take care of these cases. If you're not there, a warrant could issue. You could be tried and convicted in your absence, and if you couldn't be sentenced within 90 days because of your failure to appear, you could also lose your right to appeal. Do you have any questions about those cases?
No.
All right, good luck, ma'am.
Yeah, she had FTAs. What? Never would have guessed that. This is so much fun.
Hello.
Hello.
Hi, what's your full name?
Salvatore Giannotti.
All right. You're here on two different things. First of all, you have a warrant out of Pima County Superior Court. The charges are possession of a dangerous drug, possession of a narcotic drug, and possession of drug paraphernalia. On that charge, I will enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney. I'm appointing the public defender's office to represent you. Pretrial Services is recommending that I release you on your own signature. I will release you under Pretrial Services supervision on the enhanced. Sorry, I've just read that wrong. There. Pretrial, I need some clarification, please. It says release on our own recognizance and participate in the enhanced supervision program. It should be enhanced pretrial services. Okay, so pretrial is telling me that they think you should be released under their enhanced supervision program. The state is asking for the same thing. I am going to do that. So you need to participate in the enhanced supervision program with pretrial. No alcohol or illegal drugs, no firearms or weapons, and submit to any monitoring or treatment that's directed by pretrial services. Sir, I'm going to give you 2 court dates. I think, I'm not sure. State, you asked for a smart court hearing. Do we do that if he's already been indicted?
Good point, Your Honor. That would be a mistake on my end. I apologize.
All right. So, sir, what I'm just giving you one court date. That's an arraignment hearing. That's June 5th at 1:30 in the afternoon. You must appear for that hearing. If you're not there, a warrant would issue. Sir, you also have a warrant out of Pima County Justice Court for failure to appear, it looks like, on a DUI charge. Sir, on that case, I'll release you on your own signature. I'm ordering that you do not drive unless you have a valid driver's license and do not possess or consume any alcohol or illegal drugs. Your next court date on that case is June 28th at 8:30 in the morning. At the Pima County Justice Court with Judge Steele. You must appear for that hearing. If you're not there, a warrant would issue. Do you have any questions?
No.
All right, good luck, sir.
Thank you.
Yeah. So,
Hi, what's your full name?
Alan Mejia.
All right, sir, you're here on two different things. First of all, you have a warrant out of Pima County Superior Court. You're charged with 3 counts of endangerment, criminal damage, aggravated driving under the influence, 2 counts, aggravated driving under the influence, 2 more counts, and unlawful flight from law enforcement. On this case, I'm going to enter a not guilty plea for you. You do have the right to remain silent and the right to an attorney. I'm appointing the public defender's office to represent you. I see that this
Dang it. I knew something was going to happen. I knew it. I told you. I told you. I have to pee. Hopefully nothing goes wrong while I'm gone. And of course, the stream comes down. Of course. Yeah. Oh, man. Yeah, anybody got any good ones? The good news is I did get the docket, the whole thing. So if anything cool happened after the fact, I will find it. I will find it. But they couldn't give me what? A minute and a half longer? Do they know what I went through to get back here that quickly? No. Do they care? No. Oh. All right, guys. This has been so much fun. I like that. Yeah. I'm stripped of all ambition. Yes, I have it. I got 6 of them. So I will find the best stuff in them for you and roll it tomorrow maybe. But I think I'm done for the night because Rocky Lennon. Yeah, I went on earlier so I could go longer for you. And I'm really glad that made a difference. I love you. I really do. Y'all, I love you more today than I did yesterday, but not nearly as much as I love you tomorrow. True story. They really were. We had the crazy guy from the church who is a maritime lawyer and a First Amendment expert. And then we had the case that we decide the ending to because the judge cut it early. Oh, thank you, Joey Bag of Donuts. I wish I could see the sticker. Hold on. I can see it on my phone. It's a unicorn. Wait. Rocky Land, that's a time for celebration. Oh, honey, I'm sorry that's bringing you down, but don't. I can't tell you how to feel, but I can tell you that you are so loved. And 50 is a blessing these days. Man, people that are from my generation aren't even making it till their 40s. You're the generation before me. So, you know, you've got some years left on you. Criminy, lots of people from my high school they're not even around anymore. And most of it is bad decisions. But 50 is still a blessing. Okay, when I turn 50, you watch, I'm going to be all celebratory. But that's me. I feel like I'm blessed every day. Every single day. I feel like I am so grateful. Because there's been many times where I was real close to not having tomorrow. So every day is a huge blessing for me. I really hope that you're able to find the joy in it. Happy birthday, la 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 la. It's your birthday, yay! La 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 la. Yeah. My favorite crazy old lady. Yes. Every day is a gift. I'm so honored that you chose to spend it with me. That's just, to me, that's so amazing. You're not old. Not even a little bit. It's all in how you look at it. All right, guys. On that note, be safe, be well, sleep sweet, and much love.